everyone. We are now initiating a podcast on one of the India's hottest regulatory topics, the DPDP Act. I have with me Mr. Saswat Banerjee, who is a risk advisor, lawyer, and he is also an SME and a consultant in the DPDP Act, and he is also an advisor to many corporates. I was introduced to this subject by Saswat in 2024, and from there on, we both have been exploring this segment and its implementation and the roadmap, how this space is going to evolve. Welcome, Saswat, for this podcast. Thanks for accepting our invite.
Thank you for calling me over. It is a subject which is pretty close to my heart.
Yes, this is the most hottest topic from the corporate regulatory uh, parlance, if we can call it now. And since there is a timeline which is ticking, we still have only 9 months from now on, since if you look at May 27. So my first question to start is the timeline itself. Now that we have May 27, and so do you think it will be extended by the government? And we have seen adoptions by banks, financial institutes. There are some RFPs, and then there are some already people who have already implemented the DPDP in practice. We have seen those examples as well. But there are some entities who are sitting on the edge. They don't know what to do. There are some people who are not even bothered, negligent. They see regulation whenever it comes. Let's have a look at it. So, what is your take on that?
We have a diverse set of people. Nowhere will you find them agreeing on one path or one course of action. So, this divergence is also quite expected. Coming to your first question, it's a little difficult to say because in the past the center has backtracked and delayed. For example, the requirement of having audit logs in accounting software was delayed by a year, although it was announced 2 years in advance. So, it is possible that the government will delay slightly, but they cannot do much. Number one, because the Prime Minister himself has announced that it will be done. Second is, we have commitments under the EU FTA under which we will not get that access, we will not get a part of it if we do not implement. Also, with the number of frauds that have taken place and the public anger on cybersec or violation of cybersec, basically, I feel that if not on 14th of May, maybe it will be end of June. I don't think the government will go beyond that. One important thing that everybody should remember is that the governance and enforcement of this act is not from the central government. They are taking a hands off. If you look at, for example, the SEBI cybersec, SEBI and is following up to see whether you've done it. They are asking for the reports. Here, the central government is taking a passive role. It is the consumer, the users, and the data principals who are going to lead the matter by filing complaints. So I do not think the government will back out on that alone. The other thing, as you said, there are companies, there are banks and insurance companies which have already put their compliances into effect. So there is less room for the government to say that we are delaying it further.
See, already there is 10 years of delay in practical sense,
correct.
if you see, and there has been so many data breaches which has happened. And I think also when you are talking about your growing economy and the structure which you are going to publicize yourself on the world stage, data privacy becomes very important
critical.
for the
I
government.
fully agree with that.
So the next question is, the time is ticking. What is your advice for those people who are sitting on the edge and people who are not even started, who think जब आएगा तब देखा जाएगा?
So there's one thing which is very different from the other compliances which we have had to face. There is a lot of preparatory work to be done. You cannot switch into a compliant mode overnight. We have discussed this at various forums. Just to do an analysis of what you have to comply with, an analysis of the data, and understanding what needs to be cut off, culled if you want to say, and how you will approach it, and a change of your entire marketing strategy will not happen overnight. Our estimate is that it will take at least a month just to get the picture of the data that is there all over the company. And this needs CXO inputs and stakeholders from all over the company, various segments, to be able to come together and take decisions. In a mid-size or a large company, that is very difficult. In a small company, perhaps, where a single decision maker is giving you a strategy, it can happen. So that is the first. Second is, even if you do all that, there is a lot of strategy change in marketing. There is a major requirement of intimating to all your existing customers how you are being compliant, and it will take time. If you look at the software, and I'm sure you have seen quite a few, I do not think any of these softwares can be implemented in less than 2 months. 2 months pushed very hard.
Yes, I agree with you.
Testing, verification, and communication to the customer or your principals, even to your HR teams, is going to take time. So those who have not started it should immediately move to it. I would say you have a month's time. After that, you will be running against time, and you are exposing yourself to all the problems in the future, the penalties being the least of it.
See, adding to that, continuing our question to what we just discussed, see, we exactly have 38 to 39 weeks for the implementation. What we have seen
39 weeks actually as of Monday.
Yeah, from next week. So, a typical analysis, gap analysis, data discovery, classification takes 3 to 6 months, depending on the size of customers, depending on the vintage of the company, and also the complexity.
Right.
Rightly, what you said is just to find out where all the data is there, that itself will take a month. More challenging is to the board and the CXOs to first say we need to start. That is the first step
Absolutely.
where people are not serious about it, and that is where I think most of the time is consumed. The moment the decision is made, the speed will pick up. There are ways to do that parallelly.
Now I would interrupt you here. You are assuming that the speed will be there. My understanding is that, okay, now you have 8 main stakeholders. How many of these 8 understand what we will be saying? How many of them will be, without spending hours with the others, understand the impact of it? Your IT teams will probably understand it easier. Your legal will understand from a different thing, but once you start showing them the data and the impact, they will be confused. Marketing will find it difficult even to understand the change. Just to take a few examples. So even after they have all decided it has to be done, there will be a lot. And I think the other side of the problem which people are not considering is there's a limited pool of capable consultants and even junior consultants available. As everybody is racing towards the end, where are you going to find enough people to sit down with each of these senior members of your CXO teams to explain to them what exactly it is?
Right. See, GDPR did not affect us directly. So what you said, there's a limited resource capability here, and data privacy was never taken seriously. So
Very
the
true.
people trained or even who understand this is also very few people. You can probably count them, and the size of the market is so huge. It's not possible for you to cater. One data point from one of the events where we attended a month back. So when GDPR rolled out, they said maybe they need some 10,000 or 50,000 DPOs. Eventually, it went up to 300,000 for a size of a European market. And today, if you look at India, is much larger than that, right? And you probably the number of DPOs who are actually qualified or certified is around 3,000, right? And to this market, it is very less in number. Probably we need at least 100,000 DPOs who are certified. So that is one part. See, the other part is there are two sides of the implementation. The legal and compliance is from the privacy side. The CISO or the DPO is from the technology side. Now both have to come together, and they have to also take the other stakeholders, the marketing, the HR, the finance,
Yes.
and tell them this is the implication. See, what we have seen, most of the data fiduciaries, now if we have to use the parlance for this subject, they themselves forget that their own employees are also part of it.
Very true.
So it has to start at home, and then it has to extend to the customers, and then the biggest challenging is the data processor.
That's
So
the
if you-
big issue. Yes.
So now, when we spoke about
But
data processing,
before you go ahead on that, see the numbers you gave.
Hmm.
There are two things. GDPR has a threshold. It starts beyond that.
Yes.
DPDP does not have a threshold. On the other side, they in GDPR you needed DPOs for everybody. Here, compulsorily, statutorily requirement is only for the large players. That's a bit of help we have. But if you want to be safe, not compliant, if you want to be safe, DPOs are your first line of defense.
Yes.
You may not need a technically qualified DPO. You need somebody who has the ability to handle the customer or the
Board.
data principal who may not be a customer,
Yeah.
and calm them down
Hmm.
and resolve the problem.
Yes.
That is also not a skill which is that common. You cannot, for example, take somebody from a customer service BPO and put him here, because what they can do is follow a script. Here there is no script. Each one comes up with something, and you can't say, "I'll get back to you." That would be the disaster.
Typically a grievance officer kind of expertise, but
Most
also
probably
understands.
the people closest to it are the industrial relations people on the factory shop floor.
Yeah.
Somewhat like that nature, that kind of an attitude you will need, which cannot be trained.
Yes.
So inherent abilities are not that common. People will learn. Question is, will they learn quickly enough?
See, it's also empathy, emotion, and also the maturity of the person who are either he or she, how they are going to handle this.
All that while protecting the company's interest.
Yes.
Without being overtly.
Yes. Yes, absolutely. So now, since we touched upon the vendor part, the data processor, now things have been happening because there no compliance. There have been some basic agreements where we have outsourced to the vendors. There are some SLAs and financials discussed, but I don't think people have gone seriously to audit the technical processes, business processes, ISO standards. Now, when this kind of a scenario is existing, the business, the data fiduciary is also has to pass on a stricter agreement to the data processor. At the same time, they have to make them aware and also tell them the value and the risk which the data fiduciary is taking. And how do you think this positioning for a data fiduciary is going to be should be handled? Because data processor will not agree to sign a stringent agreement the way the rules have been laid out.
So I was helping out a law firm on this matter. We reviewed 160 vendor agreements which have been changed after DPDP on insistence of the legal team. Out of 100 out of 160, 120 cases, the vendor insisted on putting a limit saying maximum penalty cannot exceed the amount of fees paid to them. That is not going to work. You have a penalty of 50 crores or 150 crores. You can't say that since I paid you only 20 lakhs, that's the amount you'll pay, the rest I will pay. So there's a very big disconnect there. Not all the legal teams have made it clear to commercial what the impact is. That's one big change. Many of the companies do not even have a formal agreement with their vendor. They are saying the terms at the back of the PO is the agreement. That might have worked in a certain scenario, not in a new one. The other side, as you have touched on, audits. People are talking about audit of the fiduciary after it goes live. I am saying forget that. The amount of audits which have to be done on vendors after this, and they have to be technical audits, forensic audits, and management control audits. So I think once you had told me that there is 4.8 crore SMEs.
6 crores.
6 crores.
Yeah.
So let's say 4 crores out of those 6 crores are vendors for someone. The only audit standard which we have on this is SOC 2. Do we have people to do SOC 2 audits of 4 crore vendors across the country? We don't. I met with one of the very large petrochemical companies. They have 14,000 vendors.
Wow.
750 are class A vendors who are prime on this list.
That's a significant.
Yes. So if they decide to go ahead and audit every one of them, if you look at the American insurance companies which have JVs here, they have been sending their auditors from US to here to audit the service providers and the agents of these insurance companies. And from the last interaction I had with one of the auditors, it's not good. Now DPDP is much more stringent than what they were auditing before, so there is a real reason to be worried on this. So one way out which people have started to consider is not to let the data processor have the data. For example, for HR, I have seen discussions where the company is saying put the software onto our server, do a remote login and do the processing here. I cannot allow you to take the data out anymore. That may not even be possible for everything. It may be possible for few things.
Yeah.
So we have a real problem on our hands.
See, what worries me is when we were studying the industry for this whole implementation, I was looking at a large bank and what could be the size of vendors or the data processors there. I would think somewhere around 15, 20, 30 depending on the size of the banking. Now you said 14,000 vendors.
That's for one petrochemical company. It's not even a bank.
Yeah. So if you look at banks, they also have staffing companies. So some of the L&Ds have 400 vendors who are delivering training. Banks have similar numbers. So
They have DSAs, which could be considered as vendors in many of the cases.
processors, yeah. So then you also have sub-processor. there is a second layer of the
Yes.
challenge which is also coming up. It's not the first layer you're solving. The first layer agrees, then they have to go and negotiate with the second layer. And there are models where an insurance company is supporting financial services and microfinance. Microfinance is supporting some other banking lending company, but the owners of that whole liability lies with the insurance company. So those are multi-layer, multi-challenge uh, challenges which the data fiduciary has to anyway manage. I think it's a wake-up call for everybody. I think people have to invest on this rather than losing the time. There is going to be a huge significant amount of investment, but that is only in the interest of your data principal, because they are going to be your paying customers, loyal customers. If they switch, and then you have no choice of acquiring them back, bringing them back to the ecosystem.
People keep talking about the penalties. It's not the quantum of penalties.
I will come to you that the next question is that.
Okay, no, I was just talking in with reference to what we just said.
Yeah.
We'll come to that later. See, the vendor and the sub-vendor can walk off saying, I do not have the money, I am shutting down my business and going. Can a large bank do it? No. Can a large pharma company do it? Can an insurance company do it? You do not get an insurance broking entity license unless you have, I think, about 100 crores of net worth.
Yeah.
A company of that size also cannot just walk out. So the importance of having your vendors under control and protected. Other side also, I don't know how relevant it will be going ahead, but there is also a talent crunch within the processing environment. You cannot just up and replace a vendor with someone else in many of the cases. What do you do then?
No, I think it's a challenge which is going to be there for the data fiduciary, and it is also for their operations team, and significant work is going to increase for the legal team as well, right? So it's not going to
And
be
us.
Yes,
Auditors.
even auditors. And for even the implementation, it's not easy for you to convince and go and implement it, because the timeline itself is such a longer timeline.
Right.
And a company cannot go and put its 1400 companies. It's not possible. The next question is, now if you look at every ad on LinkedIn or everybody who is posting on it, they are creating awareness, but the significant portion of the awareness, in my opinion, is on the penalties. Is penalties is the selling point, or is there something else where the data fiduciary has to look? See, penalties is part of the regulation. The board will come, the board will decide what percentage of the penalties has to be implemented if the breach happens, right? And how many customers are affected. But there will be penalty for any breach which happens. There are rules and mandates around that. We'll speak about that later sometime. But how do you think one should pitch to the data fiduciary instead of creating the FOMO of penalty? Penalty is one part that everybody understands.
What none of these ads ever say is that it is not a penalty of 250 crores, a penalty up to 250 crores, a penalty up to 50 crores. Okay, and nobody talks about the 50 crores. All the ads are talking about the 250 crores. Probably the 50 crores is much more relevant in most cases. The judge, judicial officer, whoever is the one who's deciding, will take a call and will give a penalty at various levels. We don't know what it will be. Okay. And unfortunately, insurance companies cannot cover this because there is a penalty.
Yes.
Penalty cannot be covered by insurance. That's the Indian law.
It's not an operational failure.
Correct. But what people also forget is that there is something called Section 43A of the Information Technology Act of 2000,
Mm.
which rides on top of this. So even if the judge gives only 1 crore of penalty, the people affected
Mm.
can come and make claims of any amount, which is another reason. But as we go ahead, there is going to be a lot of noise on this. There is going to be a lot of negative news for anybody has been who has had a breach or who is not followed or against whom action is being taken. The recent Bank of Baroda breach is something people are already talking about. I know a few people who have decided to close their account there and move to someone else. I don't know exactly how that will help because probably all the banks are in the same boat at this point of time. So the reputational risk is very important.
I
Okay.
think it's a wake up warning alarm for the industry. Just it shouldn't have happened. If it has happened, it's just happened timely for the industry to wake up. It is not just the banking, it cuts across all the 6 crore businesses which we are talking about.
If it had happened a year later, they would have been penalties. Luckily, it has happened somewhere now.
Yeah.
But back onto that same thing, I think more than the penalties here, it is the large companies which will be forced to take action of their own on vendors who are not compliant.
Mm.
So if you are a SME, even if you're a large SME, if you have a risk of 50% of your clients canceling your order, and see one thing that when they work with the large companies, large listed companies, foreign companies, they're getting one bulk order which helps them streamline a lot of things. With that going away or that being at risk is probably a larger problem than the possibility of a penalty coming directly to them. Okay, so that I think is also something people should consider. What I'm not really sure is how much action individual consumers are going to take under this act, because in the end that money does not come to them.
Mm.
Whether the data board will take um, suo moto action, we don't know. But it is always there as a possibility, or the government might step in and bring in rules to have them do it. There are enough activists who will want to take this point up. So it's not just on the penalties. It's today very easy to have negative news show up. I think we have
Yes.
seen that.
Mm.
The recent events, how social media has been leveraged, will be a bigger problem than the other things.
What do you think for the CMOs to sell instead of all these penalties, to sell the services as a value add to the customers, saying that we are protecting your data privacy and based on your consent, our next level of interaction is going to be there and you going to be handled safely and securely and you should not be
Yes.
bothered and you should trust our infrastructure and services. Shouldn't be the message for the
See,
companies.
if you look at the cars, earlier the cars used to be sold based on the brand name and mileage.
Mm.
Today, every car is advertising their crash rating first, because that's what gives the customer the
Security.
confidence
Yes.
to buy the car. I am hoping similar thing will happen in this market also. Banks, insurance companies, brokers, and all service providers will hopefully start to project the safety of your data with them. Okay, for example, there will be pledges soon coming on the guarantee that they will not sell their data.
Mm.
It will not be now. They cannot sell, so it's making a virtue out of a vice. But these are the points. How are they going to do it if their systems are strong, if the consent management system is in place and all the other controls are in place? So that should be what the companies will sell. If that's what the companies are selling, the service providers, the CMS people should be also selling on the same.
I
See, the
think,
banks, back to your original point, there is a reason why the FOMO is not really working. Legal head says, I will tie up this matter in the courts for the next 10 years. Don't worry. But can they tie up the customer? No. Today, the word on the street is vote with your wallet.
yes.
You're not happy, you don't like it, move to someone else. There's always an opportunity.
Yeah, this is what I have seen when we visited one of our prospect, a significantly large education institute. They just brushed off saying जब होगा तब देखा जाएगा. So I think this is somewhere also the internal people are misguiding the management that this can be handled whenever it comes. Let's look at it. Let's park that question aside. Now everybody knows this is a golden opportunity. Not every time a regulatory product like this will come, and everybody wants to make a business, and this is a market share game. At the end of the day, it will be the product, how stable and how secure it is, and then the second part is uh, how you are going to be accepted as a service provider. Now, for the board to make a decision, what are the evaluation parameters for them to see with so many, at least I can see hundreds of players already in the market, because every Tom, Dick and Harry is selling the same product today, and there's also a lot of collaborations happening, and to every customer there will be tens and people who are already coming and presenting. The pricings will also be played around with a lot of freebies and all. I don't think pricing should be the decision. Rather than it should be value, the safety and security and the credibility of the team and the product. So, given your experience, what should be the things where when you select a service provider you should evaluate?
You have brought in a lot of points. Some of them counter one another. If it's difficult for us to think, it is even more difficult for the board to take a decision. So, what would they really look at? Number one, they will look at the credentials and the history and the track record of the vendor, of the software company.
Service provider.
They do not have a track record in this segment, but they have in others. Second is the complexity of the software. The complexity of how many servers will you need? Do you need only on the cloud? Do you need here? Can you do both? Should you do both? Then is the question of how sticky it is. If you are thinking that it will be sticky and you lock them in for life, it may not work. They will be worried about it. So you have to have some sort of an open architecture ability for them to extract that data if they want to
move to another
pipeline. The fourth is the ease of use internally.
Yes.
I think, see, even from a seller's point of view, the benefit of the mass market will come if it is installed and intuitive, so you don't need your consultant spending a lot of time with every client, because there will not be enough consultants to do it. So the intuitiveness and ease of install and use and monitor will probably be another critical factor. Whether AI should be a part of it is a big question mark. There are certain things where you will need the AI, mostly in the cyber security monitoring systems. Will you need it in the rest? Definitely not. But, and how, okay, one very important thing will be the design structure, which will decide how well it will integrate or how easily it will integrate with all the systems that are there in the company.
Yeah, that will be a very significant factor
Correct.
because everything has to align to the CMP platform, and then that is where you need to manage the entire life cycle. One point which you touched upon is how easy it is for the operations. It is also equally important for the customer. Like the law itself
Absolutely.
says, it has to be as simple as to collect a consent, also to withdraw the consent. So which you keep that in mind, which means the rest of the processes also should be designed in such a way that it is easy to implement and operate. See, technically or fundamentally, if you see, this is not a big thing which is so complicated, but the intricacies of the number of systems, the challenges, the SLAs, the breaches, the violations, the whatever has happened in the past, right? So those things to tighten up along with the fear of the penalties, right? And also reporting to the board as well as the data protection board as well as the internal boards, right? Those are going to be a significant exercise for the DPOs and the compliance teams. I think that is where the challenge is, as well as you rightly said, the credibility of the organization and the team and the simplicity of the platform is probably going to be the decision making parameters. At least these are the top priorities.
Correct.
Now, one part we discussed is most of it is domestic. Now we also have cross border because people are traveling. There's enough money in the wallet, and people are also traveling to India. Maybe they may not be part of it, but Indians traveling abroad or foreign companies have
Yes.
handling Indian data. So, can you give an example how this is going to impact or how this needs to be handled?
So the cross-border data has got two
Mm.
distinct partitioned cases. Let's take the simpler one first. The Act says it will cover all data collected in India, irrespective of whether the person is a citizen of India or not.
Mm.
Second part says it will also apply to data collected outside India for goods or services sold or offered for sale in India. So, if you are a customer of an insurance company in the US and they are offering you a mediclaim from in India,
Mm.
that data which is collected there will come under this act. If they are selling to an Indian in the US for US mediclaim, it will not be covered. So if they are collecting there for the data here, then that compliance, we are not yet sure how it will be enforced, because it is not going to be easy for a customer here to file a complaint against a US company who does not have a branch or business here.
Mm.
Okay. The other side is that certain regulations are there on data. Okay, first of all, if the data is collected here, it cannot be sent outside India for processing unless there's a proper agreement and the customer, that is the data principal, has agreed to it. Apart from this, the regulated entities are under certain rules under which they can or cannot send the data. For example, Master and Visa, they used to send their entire data to the US to process. Now that is stopped. Okay. Even the data of their foreign clients who are here swiping a card here, say a European or an Australian swiping a card here, that data is being sent to the US. That is also going to be controlled. At the moment, under this act, there is no specific regulations issued yet against data being sent outside. Instead, they've said whatever other regulators require has to be followed. I think we will see changes in it as the act matures and problems are brought to the light.
I think travel and payments will be a significant part of this cross-border transactions.
Probably also education sector, because a lot of Indians are studying abroad and that data is collected here.
Hmm.
It is a service offered here.
Yes.
It's not that they are going to the US and then applying to a university there. So that will be one more big area, I think.
The next question is the rights of the data principle. So, can you highlight something? What are the rights of the data principle? We've spoken significantly about the data fiduciary, that processes, and also covered some part of the board, which is the internal board rather than the data protection board. The main stakeholder is the data principle.
Right.
The entire act is revolving around the interest of the data principle. If you can just highlight about those rights.
Okay. So let's start from the easy ones. The data principal has the right to decide whether he is going to share confidential, privileged data. He has a right to say which of the fields he is going to give consent to being used. He has a right to withdraw that consent at any point of time, either fully or partially, and the right to say whether his data should be deleted or kept for the next time he comes. One more very important and a new right for us is that we have the right to have this data corrected. It's by law, he can say, you have got my data wrong, correct it. Earlier, this was only there for banks and insurance companies. Everybody else could ignore it and continue with life. Now they can't. They also have the right to demand a list or a log of all cases where the data has been used. It is very important because it can go beyond just this act. If, for example, I have applied for a loan and they sat on that data for a month, now when I am asking for this log, it will show this is the day it was logged. This is the first time somebody asked you to see it. And there's a gap of a month. That can cause a lot of problems for the people, for the banks, for insurance companies, wherever they have guaranteed or promised action within a specified time. The main ones. Yes, the right to having their grievance heard is also very important right now. And if they don't, so there are now multiple layers available. If the company has a grievance system, they have to go to it. If the industry has a grievance system like the banks have, insurance companies have, they can go to it. If it is not resolved, they can go to the data board. These three together form actually it gives the businesses enough time to respond if they were genuine. Okay. In some cases, they may even get away by saying, I'm sorry, it was a mistake, and we are now taking corrective action. One more right, which is not under this act, I had referred to it, under the Information Technology Act of 2000, they have a right to claim compensation for any data that has been shared. And that is going to ride on top of this.
See, also the rights when data principal is requesting for the data fiduciary, it is also the processes which are also using this data to process. And within that time, like we spoke, the number of vendors and the processes, the challenge for the data fiduciary and the DPO is to also get those reports within that time and report to that. And it's going to be challenging for those entities which have significant customers, especially e-commerce, banks, insurance companies. They are sitting on huge customer base. We don't have 700 insurance companies like the US. We have 60 odd insurance companies which is covering 1.5 billion. Maybe we don't have a huge population which is still not covered under insurance, but still there is a large population with less number of service providers.
Right.
So this will be a challenge for us to, the data fiduciary, to report it on time, and also to handle the queries from a data principal, and that's going to be a challenge.
I think there's one more challenge riding on this, is that if the data processor or the sub processor does not give the correct in information,
Yes,
and there
absolutely.
is a investigation ordered and a forensic team comes and finds that wrong data has been given, I think the impact will be huge from the regulator's penalty, from the reputational point of view. Even it might go to the extent of the industry regulator cancelling a license.
So the next question is, we have been living with this hype, the FOMO, and everything which we've been hearing out, and now the board is also coming into picture. Now with the high penalties which we are talking about, the responsibility and the accountability of the board to respond to those number of grievances, because they are going to be flooded with all these grievances, because significantly this is going to be a challenge for them also. Other thing also, they need to handle, even they have to be impartial to all the businesses from where they come from. So what is your opinion, how should the board uh, be accountable, and how they should respond to these challenges, because they also are not going to be big numbers.
In fact, the rumors is that the delay in implementation was lack of qualified people to man the boards benches that were planned in every state. So yes, there's going to be a problem there. They have already taken one step by putting a small clause in the rules that you have to give 90 days for the data fiduciary to respond to a complaint.
Hmm.
They're building in a buffer, hoping that the fiduciaries will take care of it. I think they will end up expanding the board's numbers. Okay. Uh, Beyond that, we don't really know, because we don't know who is heading the board at this point of time. They have not announced it. The board has been formed, but no announcement has come as to who it is. Neither have they created a public face yet.
I think some significant face will be brought in. Probably we'll have to just wait for the announcement. I think it's just a matter of couple of weeks or months, because we don't have enough time. So I think this has been a
It's a
wonderful discussion.
very interesting thing that people have not realized it, is that the Consumer Protection Ministry has started to take significant steps in this area. So it might shift. Right now, MIT is the one who's looking after it. It might shift to the Consumer Protection Ministry, who has the experience of running about 700-800 consumer protection forum courts.
Yes, yeah.
So because if you see the last two cases on dark patterns, it was not Mighty who took those cases, it was the Ministry of Consumer Affairs.
Yeah.
Maybe that is a path, but at the moment we are just doing guesswork. We have to wait and see what happens. The government still has about 7-8 months to decide what it is going to do. there are no more major
Changes.
elections.
Yeah.
So the focus of the government is now on governance again.
Also, I think it should be somewhere around November timelines. We should know because there is a milestone which we are
That
concerned.
I don't think will affect the rest of it.
Hmm.
Probably in January they will announce around the same time as they announce the significant data fiduciary list.
Yeah. Okay. Yeah. That makes sense.
But which also means that businesses will have less than 4 months, three months basically
End of
to
March.
make the changes in response to whether they are or are not on the
See,
SDF
so
list.
that is a timeline where all the businesses are closing the financial year. So the
Yes.
significant leadership will be spending time on the business
Correct.
rather than compliance. So I think it should be also considered from that perspective.
I wonder if somebody planned it that way.
No, I don't think so. I think first of all, thank you so much for coming here and sharing your knowledge on this subject. This subject itself is very new to this country,
Right.
and this is so vast. We probably will run 3 to 4 episodes of this. We've just taken one part of this because the challenges and the implementations and the number of questions everybody has around this are so large. One episode will not be able to cover all of them. So we are looking forward for more sessions like this. And thank you again for coming and sharing this platform with us and your knowledge on the platform.
Always happy to help.
Yeah. And so we are signing off from here and keep watching this space. And there'll be significant updates on this subject, which we are going to cover very frequently. And we will also bring in more guests from implementation perspective, what their challenges have been, so that we will share more knowledge. The whole idea is to make sure the people who are not yet started or who are on the edge, they understand the importance and the significance of how to speed up and how to comply with the regulations, so that you're safe on the in protecting your customers, and your customers are also trusting you on the long run. So thank you and see you soon. Thank you so much.